Hi everyone, I'm Melissa Collins. I am a certified death doula. And since stepping into this work, I have heard a lot of family stories that are struggling to make tough decisions, not knowing what the law actually is, or finding out too late that they should have done something or put something in writing. So that's why today I'm sitting down with my good friend, Bao Jennrich. She's a trusted legal professional of Jennrich Law. And she's here to answer some of the most important and oftentimes confusing questions about end of life planning. So, we're going to cover wills and healthcare directives, power of attorney, and even who has the right to care for your body after you pass away. These are things that can give you peace of mind now and hopefully prevent further heartbreak later on down the road. So, thanks for joining us.
Thank you for having me. I
Yeah,
appreciate it.
absolutely. Let's jump right in. So, part of the service that I offer my clients is an end of life planner, and it's a packet full of information about where your bank accounts are, to who you want to divvy up your possessions, to end of life funeral planning, and it's just a whole bunch of information. But I'm assuming that this is not a legal document, it's more of a way to kind of organize your thoughts. So, that leads us into kind of our first question, um, wills and trusts. Can you tell me what those are and what the difference is between the two of them?
Yeah, so we get this question a lot, especially when people come into our office and they ask, "What do I need? What is better for me?" And there are a lot of key differences between them, but I think the confusion comes from the fact that they're supposed to do the same thing. They're supposed to designate somebody to take care of your estate after you pass, and they're supposed to designate how your estate is distributed. The main key difference is a will goes through probate. And probate is just a fancy word for saying it must go through the court. The court has judicial oversight of it, and it could take several months, sometimes up to a year, depending on how big the estate and how complicated it is. A trust, on the other hand, is a very private matter that goes through that is dealt with separately. So you name a trustee, and then that person essentially is supposed to divvy up your estate the way that the trust is written. And so that is a more private matter. It is not subject to the oversight of the court, and sometimes maybe a court handing decisions that the heirs might not agree with. But essentially, they deal with the same thing. They just have a very different process of doing that.
Okay, so if you were my trustee, and I would write down my wishes, then you are a legal trustee. We've gone through all the legal paperwork, but then you're making the decisions, and it doesn't have to go to court.
Correct. So a legal trustee would be the person that would be taking care of your estate after you pass in your trust. And essentially, they would just be making sure that all the provisions in your trust are followed, everybody is getting exactly what they want, and it is not for judicial determination.
Right, awesome. So leading into that, what's one mistake that you can think of that people make all the time? So, in your experience, what's the most common mistake people make when it comes to end of life legal planning, and what's the easiest way to avoid it?
So I think the most common mistake is that number one, not doing anything. And that's a mistake in itself because you're essentially just going to let everybody figure out what your intent was before you died and what you wanted to do with your estate. And that could be very, very problematic, especially if you have a large family, and especially if you have a big estate with a lot of assets. So then you're leaving people to determine, okay, what would Bob want? What did Bob want to do with these guns? What did Sarah want to do with all these jewelry? And that leaves it up for debate, and that's how families oftentimes fall apart. The second mistake that I see people doing when they do have a trust or will in place is that they oftentimes don't update it. And the need to update a trust and a will is kind of what I look at it as kind of like the need to go to a doctor for a checkup or go to the dentist to get a dental cleaning. You kind of just periodically want to review it, and you want to make sure that the trustee that you named in your trust is you are still in good standing with them. You still think highly of them. Obviously, you want to make sure that they're still alive. Especially after you go through life changes like a divorce or a separation, you want to make sure that your ex still isn't your trustee or the executor of your estate, things like that. So, mainly updating it if you have a will or a trust, and if you don't have one, then getting one started.
Right, good idea. Yes, and it's really hard to think about that, especially when you're thriving and you're healthy and you're just busy with life, that
Yeah, absolutely. And I think sometimes it's very hard for people to talk about those kind of situations. Well, what do I do, want to do with my jewelry when I die? And people often get very teary eyed when they talk about it, even though they're very young and healthy. So, but it's a necessary conversation.
absolutely, absolutely. So that goes into really great things. We making sure that exes and people that you're not in good standing with are part of your will and trust. How do you go about choosing your decision makers when it comes to appointing like a power of attorney or a healthcare proxy? What should people be looking for in a person when they are choosing them?
Yeah, so I think it goes without saying somebody you obviously can trust. Somebody you trust now is probably the number one factor, because you likely would trust them after death. And something else people don't want to think about, and I often suggest, is obviously you want somebody maybe younger than you, just because as we get older, we want to be considerate that, okay, they might not be wanting to deal with an estate. They might be living at a lake home in a separate state, or they might not have that connection with the home state anymore. So things like that. So being trustworthy, having somebody who's hopefully a little bit younger and healthier than you, and just somebody who's savvy and who has morals and high intellect. Obviously, you don't need to have any kind of special training, like you don't need to have a lawyer background or a financial background, but things like that can be very beneficial as well.
Great. Okay. So that kind of goes in a little bit into the next question, but what's the difference, real quick, between a power of attorney and a healthcare proxy?
Yeah, so a power of attorney is just somebody who can manage your estate. And a lot of times people have power of attorney while they're still alive. So a general power of attorney is somebody who can make financial decisions for you, who can make uh, like who could sell your house if you aren't able to, who can have control of your bank accounts. While a healthcare directive is somebody who can make medical care decisions for you, meaning, okay, what do I want when this happens to me? How long do I want to be alive for? How long? What kind of care should I be receiving? Well, should I go to long-term care, or should I, be at home for those kind of care? So those are the key differences, and most people have both. They have a power of attorney, and then they have a healthcare directive, because usually a power of attorney doesn't designate any medical care.
Okay. So you have two different people, or the same person can be both.
Correct.
Right?
Yes.
Okay. So healthcare directive, you might have already answered some of this already, but what's the bare minimum a person should include in their healthcare directive? So let's go to healthcare directive. What's the bare minimum a person should include in their healthcare directive when to make so healthcare directives. What's the bare minimum a person should include in their healthcare directive to make sure their wishes are clear and respected?
Yeah, so I would say there are absolutely a few things to include. Number one is how you're going to be taken care of if you're ever, incapacitated, if you're ever in a coma, or if you're in a vegetative state. Like those are things that people don't want to talk about, but I think it's very important because obviously you can't make any decisions for yourselves at that time. The second thing is what happens to your body after you die. Do you want to donate your organs? Do you want to be cremated? Do you want an open casket funeral? What kind of celebration of life you want to have. And this is where people can get really creative in their healthcare directive. I've seen people say things like, I want everybody to only eat buffalo chicken wings because I love buffalo chicken wings. I've seen, rum, whiskey, hot cocoa, things like that, where people get to celebrate their life in the way that they want it. And the third thing is obviously who will physically take care of your body and who will physically be in control of your body after you die. Now, in the state of Minnesota, it's usually your next of kin. So if you are married, then it's usually your spouse. And if you aren't married, then it is your children, unless you have something specifically written in your healthcare directive that you want a certain person to be in control of your body.
Okay, so to summarize that, a healthcare directive helps you with the care, medical care of your body while you're still alive and maybe not able to make choices, but it also then helps take care of your body after you've passed away. Is that correct?
That is correct.
Okay. And you can, so in the state of Minnesota, so I'm married, so my husband would be the next of kin that would take care of that. But if I really want my mother, then I would need to put that in my healthcare directive to make sure it's my mom that's making those
That
decisions.
is correct. And if you don't, then it automatically defaults to your husband.
Okay.
And it's funny because sometimes I've seen people who are like separated but legally married, and it's like, well, you don't have that, specific wording of who's going to take care of your body after you die, so it would default to their legally married spouse.
Okay. And you might not be in good standing with
Yes.
them.
Yes, I would believe most would not be in good standing.
Okay. So you might have already answered this, but let's dive in a little bit deeper. Who can handle your body after death? So legally speaking, who has the right to make decisions about your body and funeral arrangements? And you can choose someone different from your next of kin. But if you don't have something written down legally, it goes to your next of kin, which would maybe be a spouse. But if you're not on good standing or good terms with your spouse, or perhaps your spouse has Alzheimer's and is in a nursing home and is not of sound mind, then what happens? Can your kids still come in and say, hey, I think mom really wants this, even though the spouse that you're either not on good terms with or is mentally incapacitated to make those decisions? How does that work?
Yeah, so a lot of the times people just have informal arrangements, right? So in those circumstances, the spouse who the deceased was not on good terms with might just say, hey, that's fine. Like your mom, you guys know your mom better than I do. Your mom and I haven't talked for X amount of years, except for that we never got legally divorced. We're essentially divorced. And so a lot of the times, most reasonable people would just say, hey, that's fine. You guys can deal with it, and nothing would ever go to the court and nothing would ever get challenged. Now, if the spouse of the deceased, wanted to have control over everything, and if the deceased did not specifically name somebody different in her healthcare directive, will, or trust, then that spouse, that legal spouse, would have the power to do so. Now, the children could bring a challenge to that, and it would have to go through court. And the challenge would be some kind of a petition to control the remains of the deceased. And then they would have to, the judge would have to make a determination as to who would control the body, who was going to make the funeral arrangements. But more likely than not, a legal spouse is more heavily considered, and the children bringing the challenge would have to prove that there is a change in circumstance.
So that makes an already difficult grieving time even more hard.
Yes. So, what I always say is that's why the updating comes into mind, right? Like if you're legally separated and you haven't filed for divorce, you can still change your trust or your will or your healthcare directive while you're waiting for divorce proceedings to be finalized.
Great. Good to know. Okay, so we're in the digital age. How do you protect your digital life? Because we live in online accounts, we have online photos, we even have digital banking. How can someone make sure that their digital assets are handled properly after they pass?
Yeah, so digital is very hard, especially because now a lot of the times emails and accounts, they're requiring you to update so often your password, right? And you can't reuse an old password that you've used in the previous 20 times, or you can't just change one symbol. Sometimes they require you to change the whole thing. I find it difficult for even myself to remember some of my passwords when it's being required to be updated all the time. But what I would recommend is for somebody to have some kind of a password authenticator or some kind of a key, some kind of an app that has access to all the passwords. That would be very helpful into getting into people's digital assets. Digital assets such as like bank accounts and pensions and savings accounts, things like that. We're not too worried about that because once that person passes, then that trustee or the executor would have control of their entire estate. Therefore, they could go to the bank and they could just get physical copies, or they could gain access that way.
Okay, so it sounds like it's a really good idea to write down where your digital assets are and passwords and stuff. So planning for minors and children or dependents, if someone has children or others that they care for, what is the most important legal steps to protect them if the unexpected happens?
Yeah, so mainly we want our children, if we pass, to have, especially underage children, to have the same quality of life that they are used to, right? So we want to make sure we have provisions in there to take care of their education expenses, their sports expenses, dance, all those things. We want them to still have that same quality of life. At the same time, we want them to have somebody they trust to oversee their quality of life and to make sure that they are receiving everything they need. So what we usually do is we have what we call a designated standby custodian, meaning that if anything, any of these triggering events happens in somebody's life, then that person automatically has power to step in and temporarily make sure that that child is receiving the care that they need. So that is temporary, and then after that, they would have to file for a permanent custodianship. But we just obviously want to name somebody we trust. We want to set provisions in there that takes care of all those things, and we obviously want our children to have a relationship with that person. So having, sometimes having a conversation with a child if they're a little bit older, and especially, sometimes I see like a big age gap between a child and a parent. I've seen, parents in their 60s and a child in their early teens. Just having that conversation, hey, I'm aging and I just want you to know this is your standby custodian if anything happens to me, and this is how things are going to go down. Same thing with pets too, right? We want to make sure our pets are taken care of. And while pets can't really inherit, we can certainly put provisions in there to make sure that people take care of our pets.
Okay, that's great to know. So just one more question on that. If you didn't have a will or a testament or a trust, who would be designated to take care of your minor children then legally from the state of Minnesota, for instance?
So if there is no designation of who would take care of the minor children, then it would pass to the spouse, who obviously, if the spouse is still alive, and then it would just go down to the next of kin. The family can make a separate decision by themselves if they want to say, hey, I want this person to oversee the children to make sure that they get everything taken care of. It can happen informally, and then they can always petition the court and tell the court, hey, grandma is going to be the temporary custodian of these children, or grandma can petition to be a permanent custodian. It really just depends, because there are things that happen a lot outside of court. And once it gets into court, then the court has judicial oversight. But a lot of times I see people just handling it informally.
That's good. Estate recovery and liens. Many people worry about losing their home or assets to pay for medical or long-term care costs. What exactly is estate recovery, and how do liens work? And what should families know to protect themselves?
That's a great question, especially with our aging population. Medicare in Minnesota is known as medical assistance. And if you're on medical assistance and you receive end of life or long term care, then what could happen after you pass is the state could seize your assets and sell them, even your house, to try to satisfy some of that debt. And that's happened to a few people that I've personally known, where a parent has passed and now there's a lien on the house and they can't sell that house because the state of Minnesota has a lien on it due to long-term care. So what we recommend is obviously pre-planning ahead of time, because there is a 5-year clawback period. Now, the 5-year clawback period applies to when you first start, either you apply for Medicare or you start receiving that long-term care. They can go back 5 years and they could try to seize any of those assets. Even though you've designated those assets to belong to somebody else, they can still come after them. So just making sure you have a good plan before you get to that age, and having a trust or a will in place, and making sure that all your assets are not going to be subject to estate recovery.
Great, good. So control over distributions. If someone sets up a trust, can they decide when and under what circumstances their beneficiaries receive money? Can you set age limits, milestones, or specific wants and needs?
Yeah, this is a really great provision that we do in trust a lot. And this is where I get to see parents becoming very creative. And, we call it almost like they're trying to control their children from the dead. And in a way, they kind of are, because they can set triggering events, right? So, for example, let's just say there are 3 children and the parents have $1 million. They could say, okay, when you turn 18, you automatically get 100,000. When you graduate with a 4-year degree, you automatically get another 100,000. When you have a child, you get this amount. When you buy a home, you get this amount put towards that home. What we always do is just kind of, as a safety precaution, is we always have some kind of a clause in there, or I suggest some kind of a clause in there that once they reach the age of like 30 or 35, that no matter what happens, they receive all of the funds, because we don't want to have the trustee administering this or kind of worried about, okay, did they fulfill this triggering event and do I pay it out? And then, essentially having them manage the estate for a long period of time.
Okay.
Yeah.
It also prevents 16-year-olds from getting $1 million all at one time,
yeah.
right?
or 18-year-olds. That's a lot of money. And it really allows the parents to make sure, the kids are being responsible after they die.
Right. I don't know if this fits into this question or not, but under a personal experience, I've seen 3 children, and one is written out of the will, and that just basically means that no matter what they do, they can't receive anything from that estate or the distributions, and it's a sad circumstance.
Yeah. Yeah, I mean, unfortunately, people can do that. I mean, obviously, there's always ways to contest anything. So, children can contest that in court. But yeah, you can essentially write people out. You can even write people out from, your celebration of life. I do not want this person attending, no matter what.
Okay.
So yeah, their wills and trusts can get very, very creative.
Yeah. I mean, I would love to live in a positive world where everything was happy and butterflies, but it just isn't that way.
Yeah.
So that's actually good to know, that if there's somebody in your circle that you don't want to be a part of anything, that you have that ability.
Absolutely.
Okay, so that's, I guess we're going into family conflicts here. This part is the hardest. This is the hardest because you're grieving, you've lost a loved one, and now there's conflict and difference of opinions. Are there legal steps that people can take to reduce the chances of family disagreement, or even keep things out of the court after they've gone?
Yeah, so in a trust, we always have a no contest clause, meaning that anybody who contests the validity of this trust is to receive 0. Essentially, we put that in there just to make sure that, hey, everything's going to be distributed the way I wrote it. I don't want any challenges to it. This is essentially what I wanted. Obviously, people can still challenge it, but having that conversation with your family before you pass, and ideally as you're creating this trust, or right after, and just telling them, hey, this is what I put in my trust, these are the provisions, this is why I'm doing this, and having the conversation with the trustee and just be very, very clear about your intent and why you're doing it. And I think if you can get that out of the way, then I think most heirs would be accepting of your intent. And then just obviously making sure you update that, right? So if there's somebody in there that you no longer want included, or if there's an ex or some kind of a dispute going on, making sure that your will and your trust reflects any of those.
Yeah. So still, I mean, as maybe close knit and close to your family that you are, and you would love to think that everything's just going to go really great afterwards, just writing it down doesn't mean that things can't change. And again, this just all sounds like it's an amazing idea, just to make sure your wishes are fulfilled.
Right. And if anything, I mean, like, you just having something, a will or a trust, is better than nothing.
So I know we've kind of touched on this before, but how often should you actually update and review your legal end-of-life documents, and what kind of changes could trigger an update?
So big changes in life should automatically trigger some kind of an update. If you're buying a lake home, or if you add children to the family, or if there's been a death in the family, especially if that's your trustee, if there's been a legal separation or divorce. So those things should automatically trigger a review and update of a trust or a will. Periodically, I would say maybe once every 1 to 2 years, if nothing big has changed in your life, just making sure that tax laws haven't changed, trust or will laws haven't changed, making sure that everything in there is the same, that you still want it the same, making sure your trustee, you still have a good relationship with them, making sure, maybe situations change where you don't want specific distributions to happen. For example, maybe I don't want the jewelry to go to my niece. Maybe I want it to go to my daughter instead. Or maybe I don't want the hunting guns to go to my son anymore because he's not into hunting anymore. So even without big life changes happening, you periodically want to look at it every 1 to 2 years.
Okay, good to know. I believe we've come to our last question. For someone who's never done an end of life planning before, or even thought about it and finds it really overwhelming, what's the very first step they should take right now?
I think just sitting down with your family and just writing down what you really want, right? Writing down all your assets, writing down all your beneficiaries, kind of where everything is, and just having a real conversation about, hey, this is what I want to happen to me after I die. Johnny, I want you to have this. Mary, I want you to have that. And I think just, because it's not a legal document yet, but that would be the start to a legal document. And that would really help an estate planning attorney like myself put together a trust or a will once we have all of that. But just having that hard conversation and just getting an understanding of what do I want to happen to me after I die? What do I want to happen to my estate? And sometimes the trust and will process takes a long time, not because on the attorney side, but more like on the other side where people are actually having to sit down and talk this through with themselves and their loved ones, and it's a hard conversation to have.
Yeah, it's hard. It is
So
hard. But just sitting down at your desk one day and just start mind dumping everything, right?
Yeah.
It doesn't have to be formal. It doesn't have to be, just start thinking things out. And
absolutely.
yeah, this can be very overwhelming. Thank you so much, Kabao, for sharing your wisdom with us today. These conversations, like you said, aren't always easy, but I think they're absolutely necessary no matter where you are in your journey of life. If you've been putting off getting your end of life documents in order, I hope we gave you some clarity today, maybe a little nudge to take that first step. Remember, planning ahead isn't about death, it's actually about love. And it's the greatest gift that you can leave your family. We'll be doing more conversations like this. I think they're very beneficial. I would love to collaborate with you again. So if there's any other questions that you think you want us to come back and cover with you or for you, please let us know. And most importantly, don't wait. Start now so your wishes are heard, your loved ones are supported, and your story is honored. Thank you, Kabao.
Thank you.